So in our last snippet, we looked at the sort of political framework behind the New York ratification debate. But this is one, there's this pamphlet literature in virtually all of the states after Pennsylvania, but it is in the New York debate that where the pamphlet literature newspaper columns reach their height, where there's this battle, and we read a little excerpts of it a little bit from this week, between the Federalists and the Anti-Federalists, and these are documents that are produced in newspapers. So here's the Federalists, and you see the type. This is very dense material, but they're appealing to a relatively narrow group of people who have influence in New York. The Federalist Papers are written under the pseudonym of Publius. Most are written by either Hamilton or James Madison, although a handful are written by John Jay, a New York politician who will later become Chief Justice of the Supreme Court. And the lead opponent, and in some ways, I think the most articulate thinker of the Anti-Federalists is Brutus, generally regarded to be this man, Robert Yates, who was a delegate to the Constitutional Convention, but who declined to sign the Constitution. And Brutus really, Brutus's arguments are at a very, very high level, and he'll make arguments. The Federalists will respond. He'll respond to them. This is essentially a give and take going on, and the high quality of Brutus's arguments force Hamilton and Madison to really sort of think through constitutional principles. And so one reason why the Federalist Papers have become so significant in terms of understanding the Constitution and really interpreting the Constitution, they're often cited in Supreme Court opinions, is because the level of this intellectual exchange between Brutus and the Publius trio was so high that it clarified on both sides. So Brutus leads off with the argument that you cannot have a large republic, that large republics devolve into tyranny, and you need to have small republics. And since the United States is a large country, the only way you can really do this in the United States is by having a very, very weak federal government, very powerful state government. And this is a period, those of you who know your European history, in which Poland, a large, it's not a really independent place, but there are some trappings of democratic rule in they elect their own king in Poland, where Poland is ceasing to exist. And so Brutus is saying, look, that's an example. You just can't have these large entities, and instead you need a smaller entity, and the federal government needs to be much weaker than the Constitution envisions. This is countered by Madison in Federalist 10. I think the most important of any of the Federalist documents, one of the most important pieces of political theory in U.S. history. And Madison turns the Brutus argument on its head. He says, look, I understand what you're saying in theory, but in practice, if you have a large republic, that will be a guard against tyranny. Because in a large republic, you'll have a bunch of different interest groups, none of whom can easily achieve a majority on their own. They'll constantly be fighting amongst each other, and so the result will be a kind of gridlock situation. So the key passage in Federalist 10, I have excerpted here in red, extend the sphere. So Madison is talking about a larger size of a country. You take in a greater variety of parties and interests. You make it less probable that a majority of the whole will have a common motive to invade the rights of other citizens, or if such a common motive exists, it'll be more difficult for all who feel it to discover their own strength and to act in unison with each other. And I think for most of American history, arguably this has changed in the last 10, 15 years, but for most of American history, the Madison interpretation of thing has proven to be correct, which is that the United States has been an unusual democracy in which it only has two major political parties, the Democrats and Republicans, but both parties tended to be more coalitions, and so it was very, very difficult to get sort of straight party line government at any point in American history. And what Madison is saying, look, that's just going to be more common in a smaller size state where you may only have two or three groups that are fighting among themselves. The Federalists and Brutus also debate the issue of the judiciary. Hamilton writes Federalist 78. This is a very, very famous line from the Federalist Papers, in which he says that the judiciary will always be least dangerous to the political rights of the Constitution. That is, that the federal judiciary is relatively weak. Again, this is true for much of American history. It certainly is no longer the case. It's a reminder, I think, of how the current American government currently has really changed its structure. Brutus counters to this by saying, look, the federal government is simply too powerful, and he seizes on the necessary and proper clause. The legislature will have an authority to make all laws which they judge necessary for the common safety. This amounts to a power to make laws at discretion. And here it turns out he's basically correct. The Federalists again say no. They say the power is only what is expressly allocated, but that turns out to be, the Brutus vision turns out to be correct. In any case, this is a debate which is ultimately won by the Federalists. The vote in New York is 31-28. It's not clear how much, the final vote was a result of horse trading, or how much it was a result of people being persuaded by these arguments. Madison, however, a lot of the Federalists, once they win and the Constitution gets ratified, basically want to put the Bill of Rights on hold. But Madison says, look, we have a moral obligation. We got this thing confirmed by promising a Bill of Rights. He solicits from the states lists of possible Bill of Rights. Madison has been elected to the House of Representatives, and he is put in charge of drafting what will become the Bill of Rights. And he collects them all together. They're a couple hundred submissions overall, and boils them down to 12 possible amendments. The first of which says that there's going to be a quite powerful, quite large lower house of Congress that will be allocated on the basis of not more than one representative for every 50,000. So this is a concession to the Anti-Federalists. What would have been the Second Amendment to the Constitution was a law that Anti-Federalists also had pushed that restricted the ability of Congress to raise its salaries, at least in the term that Congress sat. Then the other 10 amendments from 3 till 12 are what are now amendments 1 through 10. Amendment 1 is never ratified by the necessary 3/4 of states, so never enters into the Constitution. Amendment 2 does, but very, very late in the game. It's now Amendment 27. So when you hear rhetoric about how freedom of the press or freedom of religion, the framers recognized it as so important, and that's why they made it the First Amendment to the Constitution. This is really something of a fluke. It became the First Amendment because the first 2 amendments as drafted weren't adopted at the time. The First Amendment, what Madison's proposed First Amendment, would have led to a dramatically different structure of government if it had been approved. To give you an example, so this is the Brooklyn College Congressional District. This is the 9th congressional district, population of roughly 800,000 people. So if this proposed First Amendment had been adopted, this amendment, the Brooklyn College Congressional District would need to be subdivided into 16 separate congressional districts. So you'd have like one that would have the college and the junction and a few surrounding areas, and that would be sufficient number of people. So the result would have been a House of Representatives that would have just been extraordinarily large and almost completely unwieldy. So in retrospect, the country was probably lucky that this amendment didn't get adopted. Ultimately, then, the Bill of Rights consists of the first 10 amendments, all of which, of course, deal with different matters. But I think you can really divide them into 3 sets of amendments. So amendments 1 through 4 are limitations of various types on congressional power. The First Amendment is by far the most significant of these amendments, providing freedom of speech, of religion, of assembly. Amendments 5 through 8 deal with the judicial process provide protections for accused criminals and those who are subject to arbitrary power by the state. Of these, the Fifth Amendment is the most important, particularly because it involves the Due Process Clause, which will expand individual rights in the United States as a result of a variety of court decisions in the 20th and 21st centuries. And then the Ninth and 10th Amendments are structural. They say, look, it's sort of a remnant of this James Wilson argument in the Pennsylvania ratification debate. They say anything that's not given to the federal government necessarily is reserved to either the people or to the states. The problem, of course, is that Brutus was ultimately correct here. And Brutus said that this necessary and proper and general welfare clause will give Congress authority to legislate on almost anything. And so the Ninth and 10th Amendments have tended not to be major forces in American constitutional law. There are relatively a few key decisions that are based on this, and especially once we get beyond the New Deal in the 1930s, these amendments provide very little restriction on federal power. So that's our lecture snippets for this week, and that brings us up to 1789 and the beginning of the constitutional system.